Good morning.
Good morning, Your Honor.
We're here on cause number DC 20-16654, Dallas Palms versus Dick Mechanic et al. And this is defendant's motion to compel. Can you just tell me who you are and who you represent, please?
Yes, Travis Livermore for defendant McAnich.
Craig Henderson for plaintiff, Dallas Palms.
And I'm Eileen Glazer. I'm here for one of the defendants, Vic Jones.
Okay, Mr. Livermore, I've read the pleading, so I'm kind of familiar with the background of this case, so you don't need to go through that, but if you feel you need to refer to any aspects of that in your support of your motion, feel free to do so. So since this is your motion, please proceed, sir.
Thank you, Your Honor. May it please the court. So we received responses from plaintiff to our discovery request, our first request for production, and also our first set of interrogatories sometime around last May, I believe, when we received those responses. Plaintiff at that time did not produce any documents other than what it labeled an Appendix A, which it attached to its interrogatories and was a purported answer to part of the interrogatories. In response to the RFP, plaintiff didn't produce anything at that time. Plaintiff has subsequently produced 193 pages of documents, which we received here a couple of months ago this year. But 193 pages of documents seems very low in a case in which plaintiff is claiming damages in excess of $800,000 related to a construction project. Plaintiff has not taken down its objections, and specifically, Your Honor, with respect to requests for production 1, 7, and 24, RFP 1 asks for the plaintiff's project file. Plaintiff has objected on the basis that it says project file is vague and ambiguous. I don't think that term is vague or ambiguous. I think that when you have a construction project, especially one where you have this amount of money involved, that you would keep a file even if you're on the client side of that project. So I don't think that term is vague or ambiguous, and we would ask that the court order the plaintiff to take down that objection. Also, with respect,
Mr. Livermore,
yes, sir.
Let's just do one of these at a time. Let's just deal with that first objection. If you have something further to offer on that, please do.
Okay. So what we would like is, and I guess let me see if I can just share my screen here, Your Honor. That might be easier just to look at the response that we have.
Okay, I may need to give you permission to do that. Let me see.
Yeah, it said it was disabled, so.
Okay. Okay, you've been made the co-host and you should have permission to share your screen at this point.
Okay. Okay, so this is plaintiff's objections and responses to our first request for production. Can you see that, Your Honor?
I can, yes, thank you.
Okay. So going down here to the first one, and we asked for a complete copy of plaintiff's project file for the design and construction of the project at issue, including written contracts, subcontracts, plans, designs, correspondence, texts, emails, project meetings, warranty claims, punch lists, and other items in the file. The objection here, as you can see, is that the term project file is not defined, vague, and ambiguous, and is overly broad. We would like for the court to order a plaintiff to take down that objection I don't think there's anything vague or ambiguous about the term project file. And it's certainly not overly broad with respect to a construction project that is what underlines this suit. And we would ask that plaintiff be ordered to produce any additional documents it has that are responsive to this request.
Thank you. Mr. Henderson, your response?
Excuse me, Your Honor, and I apologize
Excuse me
for
one
the sun
second.
in my.
Why don't you take that down, Mr. Livermore, would you please? Can you stop? That's fine. Okay, go ahead, Mr. Henderson. I'm sorry.
Thank you, Your Honor. I apologize for the glare in my face. I can't get rid of the sun in through my window. But I am a little bit confused about what defendant is moving for this motion to compel. What Mr. Livermore just pulled up was a request for production back in 2021, where we sued originally Dick McAninch, if you will. Dick McAninch passed away that summer in 2021. And those requests for production and those responses were served back in, I think the date, I'm not going to ask Mr. Livermore to pull it back up, but it was in 2021. And at that time, we had produced to Mr. Livermore's firm, and he's also representing the newly added Richard McAninch, his son, who was under a writ of Skyry fascist back in December of 2021. Mr. Livermore's firm was representing both. And let me just be clear that when Mr. Livermore says we've only produced documents in the last couple of months, that's not correct. We produced 193 pages of what was in our files back in 2021. So I'm a little bit, I don't know if it's a proper term of special exception, but one, I'm not so sure which defendant is asserting this. Is it Mr. Richard McAninch on behalf of Dick McAninch in those requests? Or is it Richard McAninch's son, who is now his representative? Or is it Richard McAninch individually, which we sued as well because of the blending?
Let me stop you, Mr. Henderson, 1 second. What difference does it make which defendant is making this request?
Because we need to know which request he's talking about. I mean, which set? The court does not have before it, other than what was shown on the screen, what the actual requests were and our objections. There is no way for me to, or the court to understand what's before the court to make rulings on these specific objections. For instance, what's in the motion, Your Honor, is not, there is no objection attached to it. He's parsing out sections of it, and it'll be important to show that some of the objections are not fully disclosed. What you would typically expect to see is a motion to compel, here's the responses, or here's the request, and here's the responses to the objection. So the court can have before it what is actually ruling upon.
Okay. Let's get to the crux of this. I'm gonna read this request, and I want you to see if this response is your correct response to that request. I don't want to get sidetracked on a lot of the issues. It says, please produce a complete copy of your project file for the design and construction of the project at issue. This includes all written contracts, subcontracts, plans, designs, correspondence, texts, emails, project meetings, warranty claims, punch lists, and other items as contained within your project file. And it indicates here on the motion that you objected the term project file is not defined, vague,
Correct.
and ambiguous, and overly broad. Subject to
Correct.
the foregoing objections, plaintiff will produce document responsive to this request at the DTP. Was that
Yes.
your response?
Yes, it was, Your Honor.
Okay, now I want you to defend that response.
We produced 193 pages, which was essentially all our documents that we have for this particular construction deal. The project file is more in terms of a term that's used for contractors and professionals in the contracting business. We are a multicultural, multi-denominational event venue with a very nice lady that's running the business. and she opened up her file cabinets and pulled those documents. But to the extent, what is a project file, we don't know what that is. So that was the basis of our.
Let me stop you right there. I'm going to read from your pleading, your petition. And you said in your petition, plaintiff operates a full-service event venue located at 2424 Marsh Lane, Carrollton, Texas, for weddings, receptions, corporate functions, and specific events, the property. In 2018, plaintiff desired to expand the improvements located on the property to accommodate more guests and or events. The project. What did you mean in your pleadings by the project?
The project is what was contracted for by the defendants.
So why is that term vague now in your responses?
Your Honor, again, at the time I did the objections, I was not thinking in terms of that project. I was thinking in terms more of project file, like architects, engineers, as a term of art. Your Honor, I am not going to quibble over that. If I have no problem with taking down that objection in light of what the court's concern is.
Okay, let me say this, guys and ladies. I know motions to compel can be substantive, and they can be there can be some very right reasons to produce these, but discovery disputes, I think, are a waste of your time, the court's time. You got plenty of clients to work with, you got plenty of files to look through, and you don't want to spend 45 minutes with me arguing over something that professionals should be able to resolve. Okay? So I'm going to do this. This first motion, I'm going to ask that your objection, I'm going to rule that your objection is overruled. And I'm going to suggest that you guys take about 20 minutes, call me back, and go through the rest of these, okay? I'm not a fan. I think all cases should succeed based on their merits. I'm not a fan of outdated, sometimes unprofessional hiding of the ball techniques. That doesn't sit well with me, okay? If you got information that you're going to present at trial, I think the parties are entitled to. You guys sit down and look at these objections again, and I hopefully that the two of you will be able to professionally resolve these issues with time frames, specifics. I want an order that's going to be very specific. If you cannot do that, it's 9:43. Call me back at 10:30, and we will resume this call, and then I will make those decisions. Okay?
Thank you.
But I'm
Thank you, Your
hopeful
Honor.
that, as professional attorneys, that you guys will sit down, understand what's being asked, and make a due diligent and earnest effort to provide that information, okay? So we're going to resume at 10:30, and hopefully you guys will have an agreed order that I can sign. Thank you. You're all dismissed.
Thank you, Your Honor.